We are live. Good morning. Welcome to our October 25th meeting of our environmental concerns and real property tax services. Can I first get a motion to approve the minutes of our prior committee meeting? Supervisor Dickinson on the first, supervisor from Queensbury, McGowan on the second. Any discussion? All in favor?
Aye. Aye.
Opposed? Unanimous. Three, any privilege of the floor in public comment? Is there anyone who would like to address the committee as it relates to any issues? Seeing none, basically, why don't we turn it over to our department head?
Okay.
Lexi.
So the number 4, the first action agenda item is a resolution request to authorize the conveyances of lands offered at the public auction on October 15th. This is just standard housekeeping after our auctions. So the parcels that did go to auction are listed in this, and the outstanding taxes were $140,114.26. And the sale prices of all of those parcels totaled to $442,950. So we will pay off those back taxes. We will also be able to put the $150,000 into the revenue code in the treasurer's budget, even though I think it should be in the real property budget, but we won't go there. But anyways, so that's your resolution request.
Supervisor Dickinson.
I move that. Second.
Any discussion? Go ahead, Supervisor McGowan.
Yeah, I'd just like to reach out and thank our director. Really, it's a lot of hard work getting there, a lot of work, period, getting there. And then to bring that kind of money in. So a lot of the properties do have a net worth at the end. So this is great, and thank you. I just want to thank you for all the hard work.
May I ask a question on relative to?
Sure.
I noticed in the town of Bolton, there was a sale for $83,000.
Yes,
What was that?
it was just vacant land, but
How big was the parcel?
oh, Peter. Do you remember? It might have been. And just so you all know, Supervisor Leggett did come and sit with me at the auction and took notes. And yes, we had 2 members from the county attorney's office as well. They're observing. So, but that particular piece, the Lake George Land Conservancy wanted it because there is a stream that runs through there, and you know, hopefully for trails, I believe for hiking purposes. I'm kind of looking at
the supervisor from Bolton.
He's not here. So anyways, but they were really interested in the property. I think there was another couple that was also at the auction that was interested in the property, so they kept bidding as well. So that is why it ended up at such a high price.
So we vote on that last. We have a motion on the floor as it relates to Lexi's authorizing the conveyance of lands offered at public auction. All those in favor?
Aye. Aye.
Opposed?
I should recuse.
Used.
She bought one of the lots.
No, I did not.
Here.
Mr. Chairman, what would be the total going back to the environmental reserve fund?
You know, I
Is that a percentage?
did not keep this. I might be able to find it in my email. I forwarded that information out to some of you. It is a percentage. So what ends up happening is we pay off all the back taxes, and then we pay the revenue code, which is 150,000. And then the balance that is there, we take 25% of that balance, and that goes into the reserve testing fund.
It's about 40,000.
It was like 38,000 and change. Yeah. So that is what'll go in, and then the balance after that which I, for some reason, I'm thinking like 114,000 maybe, or maybe that was before the 38 came out, is gonna go into the general fund. So, not,
Buddy,
This is probably a bit of a curveball, but I also think that the committee and the full board should authorize maybe retroactively the authorization to stipulate and settle out some of the foreclosure properties that did not get sold at the auction.
Excuse me.
My understanding is that a couple of the property owners or their representatives made motions to the court, and that was settled out of court, and the county attorney's office signed a stipulation. I really think that that should have been approved by the county board. And at this point, we have to do it retroactively. Then let's do that.
that would be a question for the county attorney's
I
office.
don't think we need to do it retroactively now. I mean, it would be rubber stamping the court, having so worded the stipulations at this point, and they're all signed as court orders from Judge Mueller. I mean, I think if you wanted to do that, you could, but we've already got our stipulation as a so ordered, so now we have a court order that would be in a sense rubber stamping.
Well, my point is that before the stipulation got signed, the county attorney's office should have been authorized by us as a board to sign the stipulation, unless I'm misunderstanding and it was a court order in the first place, withdrawing the properties from the foreclosure. But I don't think that was the case. I think it was agreed upon stipulation.
Based on having filed motions, orders to show cause with the court down there to pull these parcels, have them, taken out of the foreclosure proceeding.
so your point, I think, is that we've done it already, and just doing it retroactively is just kind of maybe a moot point. Claudia's position is that we initially should have taken a position, this committee as it relates to the properties involved, so.
So last year we had a similar situation in the same thing. There was people that, held right out towards the end, and then they filed order to show cause with the judge. And last year it was before Judge Offerdew, and everyone that filed an order to show cause, he signed, and then we had to do deeds back to the people last year. So this year they, I'm assuming, filed order to show cause, all of them. And then I don't know, I didn't follow it this year as much as I did last year. If you guys just agreed to do stipulations, or did the judge actually sign those orders, sign off on those order to show causes? I guess is more the question you have, right?
Supervisor Dickinson.
So in that case, the landowner would have paid for the attorney, the deed, the filing and all that. You're saying no? Well, who did?
It was because it was in relation to the tax sale. I believe it was exempt, as I think how it went through last year. For the deed purposes, for anything that they did in court, I'm assuming they would have paid on their end if they had an attorney on their side, or a lot of them, I think most of them just filled the paperwork out themselves last year. I don't know what happened this year.
So were these standalone pieces or did they go back to the neighbor?
No, they were pieces that were standalone in the foreclosure. We did everything all the way through. We followed the law, but they weren't happy in the end, and they decided to submit an answer by filling out an order to show cause with the courts.
So
Try to keep their
So
title.
the title people for the property didn't pay the taxes.
Correct.
So
They have now.
in arrears. And then they let us go through the whole procedure before
Whole
they stepped
entire
up.
procedure, correct. We even had actually taken title.
Is there any way we
I'm
can
not
prevent
mistaken.
that?
That's what I'm saying, is that we should have had an opportunity to make a decision about that at the committee meeting before it just went back to them because we try very hard to follow the process and we have a cutoff and we told other people, no, this is the cutoff. And if you don't pay, you're going to the foreclosure. And we just let these people out
But
at the 11th hour. I know they filed motions, but that's not a court order. That's them complaining about the process.
but
And Larry, I did talk to the county attorney and has good, reasons for seeing the concerns that the people made, but why shouldn't we as a committee and the board have authority to say, well, yes or no, we want you to defend the case?
I think, if I may. Part of it is the timing. If we had, at that point, it was literally the week of the foreclosure. So we would have had to have called an emergency committee meeting for you to make a decision as to what we were doing. Otherwise, I think we would have been pulling them. We wouldn't have had a way to pull them out of the auction at that late in the game, and unless the judge either signed beforehand, or I don't know the whole process that went on with the stipulation. I don't know what were the dates that the orders were filed with the courts.
I don't know all that either, but we had a full board meeting on October 6th, which was 9 days before the auction.
I guess we would have to have more answers from the attorney's office because I do not know the dates that all of those orders to show cause were filed. And wouldn't have done anything prior to that. Without, how did we know if they were really gonna file? Once they filed,
Right,
then
I
we
know.
could have
Yeah.
tried to bring it, but again, that I think falls on the attorney's office, not mine. I don't
No.
stay on top of the court's website to know what's happening with all of them.
I mean, we're kind of at the whim of people that way too, if they do want to file a motion or want to show cause with the court prior to the bankruptcy and prior to the foreclosure, or we can't prevent them from doing that regardless of whether they have a good case or a bad case or whatever. I mean, if they're going to do that, we're kind of having to just wait it out and see if somebody does file it. That's always kind of the nail biter in those final weeks and days before the foreclosure auction itself.
Thank you, Mr. Rick. Wow. I know this has happened, it's happened in the past. I guess my question is when we're waiting to the last minute to pull them back, we have done so much legwork and it has cost the county time and money. Do we recoup any of those costs for this last minute? I mean, everybody has a chance to pay their taxes and to pay the, the overcharges when they come, or the percentage of, late fees, but when you wait until the last week before the sale, there's a lot of expense that goes into us and a lot of time. And, if they're gonna be taking it and the courts are gonna allow it, do we have it in there to recoup these costs?
It depends on what cost you're looking for. We do recoup any of the cost for anything that has gone on through the year. So, the mailing fees, the posting fees, any abstract fees. And then every month, there's that additional 1% that gets added on through the treasurer's office. So when these stipulation agreements were done, when they paid, I don't even know off the top of my head what days they paid, but the ones that did pay had to pay, those fees were included in what they paid because those automatically get added on as that stuff is done. So when an abstract is done, that information gets sent to the treasurers, they add those fees in. So those are fees that were, accounted for when they paid. They had to pay everything up to date on these parcels.
Right.
So they made us whole.
They did. We're
As
made
long as
whole.
we're whole, yeah, I mean, I'm still like, I agree with my counterpart from Glens Falls that we need to have certain things in place and, and it's not like we just pull these out of our hat and decide to go to auction. And at the last minute, I just want to make sure you know,
Mhm.
the county is whole and the taxpayers aren't the other taxpayers that do pay their taxes aren't picking up any of the tab.
The Supervisor Garrett,
I talked with the county attorney also. It was my understanding, and I don't know how many there were. I knew of one, you know, Robert, how many there were?
5.
Oh, there's 5.
Five.
But when I talked to the county attorney, there was something, they were making a point about the service on a couple of them or something was gonna change. And felt that rather than use the court's time, and they're probably gonna get what they wanted anyways, he made a determination, okay, we probably will not win that in court. Now, I understand how you wanna be brought up to speed on that, maybe. Notice to the committee or whatever to be brought up to speed. That's what I understood, that there could have been something in the service that they found to be irregular or not proper, and they were gonna take it to court, and the county attorney felt that we probably would lose that anyways. We did get paid in full, the full amount, and we're made whole, so I don't have a problem, I can understand, but I think they found something in the service that may have caused them to think that they will go to court, and I think the county attorney felt that there again, the courts will probably decide. I mean, anybody who's in government knows now that, it's very, very hard to get a lot out of anything, water, sewer rents, this rent, that rent. So I think that's why the decision was made by the county attorney's office. I really feel it is.
Yeah.
Yes, thank you. Another thing, I think, we have to look into, and really, I know this has happened, quite a few times in the town of Queensbury. But developers come in and they buy this land that, has a lot of land use around it, and then we have some land within that land that's not. And when they subdivide it, they subdivide out the wetlands and this and that. And once the development is filled out, they just stop paying taxes on that. And I know there was a piece of property that went on this for sale closure, and that's something that we need to address. And I will be addressing at the planning board and putting it in a resolution. As long as I sit on it, is that yes, this development's coming in, you are buying all this land, you need to pay the taxes. There's no way that just going to be turned back in and walked away from. And this has happened a few times in Queensbury, and I'm sure that, as we're getting down to limited land around our whole county, a lot of it is wetland or too steep or this or that, and they take what they can, and handing it back to go into a foreclosure is to me is not good business.
Just to let you know, I have spoken with the town supervisor in Queensbury. And he was going to also work on that. So you may want to reach out to Supervisor Stroh. Maybe you guys can work together on that. I know that he did want to as well work on that and make it so that there would be some type of stipulation put in there.
Yeah, that would be great. Thank you. And I'm just reaching out for all the other supervisors too. To make sure, because this is what happened, and I don't think it's fair. These builders, make their money and then they turn around and say, well, hasta la vista, I can't use that. And thank God there's someone that feels that they can do something with that land, or just wanted that land for accusation of something. So, but thank you.
Supervisor Bramer, are you okay with the
I'm not satisfied. The last time I checked, we're still the executive body. And the county attorney's office should have obtained our permission prior to signing settlement agreements of the litigation, unless we want to, in the future, just give him that authority or give that office the authority to do this in these instances.
I think we would, my personal opinions. This committee and board order to maintain that authority. So
Maybe we can bring a resolution for next month with the 5 properties.
Okay,
that already were.
that would be, I think that's a reasonable approach. Good. Thank you.
Good.
I'll make a note in my calendar that if next year, when we're getting closer to this, if we're, anyone is reaching out to us with a possibility of an order to show cause, I will discuss it further with the county attorneys at that point and maybe at my September committee. If we're aware of anybody that may be doing this, we can bring it to committee and make sure you guys are aware, only if we know. I mean, because like I said, some of them wait literally until the week before and file stuff, which makes it very difficult on us pulling them out at the last minute. But I will definitely make a note in my calendar to, as a reminder for next year, to confer with the county attorney's office and bring any information that we may have in September to those, okay?
Thank you.
We have a couple of discussion items on the agenda. We can pack it in terms of what it is. The first item had to do with the language that was removed from the tax and foreclosure deeds. So we have the old language, the language in our packet that was removed, and then going further in it, we have the resolution that was passed in October by the board, approving the new language and removing the language that was objectionable. Let's see, did you want to get into a discussion in terms of why the language was removed or not, or what
So,
you want to say?
so we decided at the last committee to move this forward through the board, but to bring it back for possible further discussion on what was at one point in the terms and condition, paragraph 6F. I know that Supervisor Bramer had asked about discussing this further. So I think she felt that there should maybe be some type of language, but I don't know if anybody has talked about anything since committee meeting of any further language that should maybe be put in or not put in. I know in our discussion that we had at our last committee, it was kind of an agreement that over the past 3 years, this language was in, and only one person over those 3 years had gone to Charlie Wallace's office and applied to get a building permit. Nobody had else over the 3 years of sales had done this, had gone to Charlie to even apply for a building permit. So I think you all felt, and I don't want to speak for you, but I thought the consensus of the committee is that this language wasn't working in the terms because nobody was using it or following it. These terms and conditions are read every year at our tax foreclosure sale. The auctioneer is on a microphone and I make sure that he reads them before every auction happens. So this year they were read without 6F because of the resolution that was passed at the early board meeting in October. So I'm good with the way they are now. But if the committee has further discussion, I'm willing to hear any of it.
Right, just to provide context for this, and correct me if I'm wrong on this. 6F was brought in because properties get sold through tax sale. A lot of times they're in very poor condition. People buy them because they're a good deal. They do nothing with them. They are blight in the community for years to come. So it was the county's attempt to move along the process that went in a change of ownership. The new owner would do something to improve that property so it's no longer a blight within our communities. It had some legal problems with it, so it was removed, but that was the intent behind that section.
Thank you. Supervisor Dick.
So where are we now? Have you talked to Barb Krugman?
I have. I've had a couple of different conversations. So I had a conversation with Barb Krogman who owns Community Title, a local title company in the area. With this language being put in our deeds, we are making these properties unsaleable. If somebody tries to turn around and sell these properties and this language is in the deed, the title company will not write title on.
That's the old language.
Correct, with the old language. Title companies are not able to write title for these. So that is why, this is where this all started, was we had a gentleman and his attorney, Lou Roth, show up here and request that the board give him back a deed, a correction deed, removing this language so his client could sell his property. His client had probably done 75% of the work, but this property was in the town of Queensbury. We cannot overrule Queensbury code. Queensbury has their own code enforcement office. This language should never be in any of the deeds for the town of Queensbury. Town attorney for the town of Queensbury, Robert Hafner, did put something in writing, because I had reached out to Supervisor Stroud, who then reached out to their attorney, who then stated that I was correct, that the county cannot overrule town code in the town of Queensbury. So this language would not work for Queensbury at all. And over the last 3 years, it was in any deed for any property from the foreclosure that sold in the town of Queensbury. This language was put in there. So that is another issue that if we want to talk about it today, that would be great. That we also have to look at are the deeds that have already been issued over the 3 years with this language in there. People are going to come forward and that aren't going to be able to sell their properties. And like I said, over those 3 years, only one person, and it was on one piece of property in the town of Warrensburg that already had a building permit. The guy who bought it at the auction went and renewed the other people's building permit. That is the only one that Charlie Wallace said has come through his office on any of these foreclosure properties. So, you know, I just think that it will come to light sooner or later when somebody tries to sell their property with this language in there. They're going to have difficulties. You know, I mean, Barb Krogman's been doing title for years. And if she's going to tell me that it is making the property unsaleable and not to be able to issue title insurance on a property with this language in there, I don't understand how legally we can put this language in there. So that is what gave you guys the consensus to take it to the board and remove it by the resolution that just removed it, which was 5/15 of 2022. So I don't know. Again, if there is other language that somebody wants to consider to come up with to put in its place, so be it, and maybe discuss it with the county attorney's office.
Dennis or Supervisor Allen?
Thank you. So the wording is just to make sure that somebody does something with the property, just doesn't sit on and keeps it an eyesore.
I
mean, basically,
have the
yeah.
language.
I mean, I remember discussing it before, but it's basically to protect the county and the sale and the towns. That once the sale goes through, people have 24 months to do something with the property and fix it up.
And if they don't do it within 24 months, they could come and apply to the county administrator with a fee of $250 and get an extension for another 24-month period.
How many people have done that?
Nobody, because only one person even got the building permit. So
So right now, we don't have that.
this language was removed.
Okay.
As of 5/15/2022.
But we have 3 years prior.
But we have 3 years prior that language is in
But it's
there.
really only 2 years, right?
No,
Or
this would be the fourth.
so can we handle that? Those cases as they come in? If by case, I mean, and I mean, I understand protecting and most people are gonna buy these properties at a good deal, you know, are going to, hopefully clean them up and, you know, make them livable again to either one resell or not, so. You know, I don't know why we can't put in there, you have 24 months to get this fixed up, or otherwise it goes back on the auction plate. Period.
Because you can't just put it back on the auction
I know.
plate, then you would then revert back into this language. That is where the county states that. What's in here? The purchaser has not complied with the deed provisions regarding rehabilitation of the property and obtain a certificate of occupancy or certificate of compliance. By that time, then the county may, subject to board approval, commence legal proceeding to retake the title. So that means that's gonna cause the county attorney's office to have to stay on top of all of these. And then they would have to, I don't even know how you'd go about, I guess, because the language is in there, file something with the courts to try to regain it. It's
But
become-
could they get title insurance with that wording in there?
with the old wording,
No, not with the old wording, just that one thing saying that, you know, after 24 months, the county has the option to refile the take back title.
I don't know, that would be
That'd be
something.
something that maybe we need to look into. It's just protecting the towns and these people that, you know, a lot of other towners, I mean, I have a friend that looks online. And he doesn't hardly even looks at these bills. That's a good deal. I'm gonna buy this piece of property. The last one, he particularly went up there, looked at it, and he says, you know, it's gonna take a little bit more work than. And I thought, but it's a good solid building, you know. But some people, you know, and I know he's capable of doing it, but some people might get into it and say, geez, that's way above, and it's gonna cost more than what I want, so. I don't know.
I think that would also have to be further discussion with, say, some of the local title companies, because they're the ones that would have to write title insurance. And depending on the language that you're looking to put into there. So if it is something where you're trying to come up with language and say the county attorney's office comes up with some type of language, they may want to talk to some of these local title insurance firms to see how they feel it would affect being able to write title. Because when you sell something and you're gonna have a mortgage, then you have to have title
Mm.
insurance. So,
Gary, did you have anything?
Yeah. The town of Warrensburg brought this down to the county several years ago. Our code enforcement officer was reading, and we had blighted properties that people would buy for next to nothing and let them sit. So we brought it down. It should have modeled the city of Kingston's when they sell the properties, the city of Kingston put this in their thing. There was discussion, we agreed it would help the towns get these people who bought these properties at a real decent price and didn't do anything with them. And then it falls back on the towns to make them do something, and they were buying them for foreclosure. Now, since we enacted this, I don't know where we have many cases in our community where somebody's bought something through the tax sale, and we've had to go after them to make them do something. It gave us more teeth on a local level to get these properties cleaned up. That's where it came from. You go back, you look at the minutes, we brought it in from the city of Kingston. City of Kingston's had this law on the books for many, many years. They do it with their sale. That's why we asked to do this. And I believe it's helped, although we do. I just heard last night of another house that was purchased and it's left abandoned. And we're gonna have to go after them, but this is why it was put in. So somebody wouldn't come in and pick something up and just let it continue to be a blight on the community. If they bought it tax foreclosure, didn't do anything with it. The whole concept behind it, I think it's helped us a little bit. I'm not 100% sure, but that's it. I didn't know that people couldn't get title insurance. First I heard of that.
Is the consensus of the committee is that we seem like we have a handle on the issue, and I don't think anyone's asking us to do anything different, are they, going forward? That we've removed the language, we put new language in place, and we just kind of, life goes on. And the So I don't know how much further discussion we want on this. There is another item on here, okay? And it has to, and it actually is a further discussion requested by the Committee on Real Property Tax Law, Section 467. Exemption for persons 65 years of age or older. Plus Section 467, if you were to define that, what that does is it gives local government and public school districts the option of granting a reduction in the amount of property taxes paid by qualifying senior citizens. Included in your package, you'll see Resolution 251 of 2012. Okay, this is the last time this board took some actions as it related to property tax exemption for senior citizens. Also included in your package, you'll see a recent change made by the New York State Legislature, the Senate and the Assembly, which changed their guidelines as it related to what the amount of money would be unable to be provided the exemption. So Lexi, at that point, why don't you kind of summarize and maybe give us maybe a recommendation in terms of where we ought to go?
Sure. So currently the county is at 24,000 for a max income limit. Which that 24,000 is the 50%. The county does go down to 5%, which allows down to or up to an income of 32,399. There was another one of these done in between. I don't remember the year that the state did pass it. But they did change before this increase to 50,000. They did do 29,000, which 29,000 would be the 50%. Down to 5% would give you $37,399.99. I did give you a chart showing you a couple of different synopses of 35,000, 50,000. As far as I know, throughout Warren County, none of the schools are looking to move forward to 50,000, nor have I heard anything from any of the towns about moving forward to 50,000. The town of Queensbury did, and I believe was the only one that moved forward. The last time New York State increased this to 29,000. If the county was considering doing anything, I would recommend only going to the 29,000. I really wouldn't recommend the 50,000. It's a high number. New York State is the one who does the income verification program now, so the town assessors don't even see everybody's income anymore. They took that away from the towns. So the state did put something out, and based on the adjusted gross income of people, there could possibly be another 2,286 people in the county that this could affect on the 50,000. But bear in mind, that's New York State only bases things on the AGI. They don't take into consideration people's actual income. So say you have, say you own a house up on the lake and you have a bunch of money in the bank, that money in the bank doesn't count as income. So, you know, IRAs are not income, but their interest is. Same with a pension, the interest is, dividends, wages, all of the Social Security, when they're filling out an exemption for this, it has to be looked at. So like if you fill out your income tax return and there's something in the left and something in the right, one of them is your whole dollar amount. Like let's say you have 30,000 coming in from Social Security, that's over here on the left. And on the right, you're only using 10,000 for your number that's actually being used in your income tax. Well, when you're applying for this exemption, your whole 30,000 has to be looked at as income. But New York State isn't including that whole 30,000 in your adjusted gross income. So the numbers that even New York State gave us aren't really accurate. So it's a guess, it's a guessing game. We don't know how many more people this could affect. So when we looked at the stuff before, somewhere. So when we just kind of took the current exemption amounts and then say potential exemptions, we're looking at there could be a possible potential impact of 76,602 for the county. You know, that's dollars that would be out there in this exemption. So, you know, but that was before we knew that there could be 2,200 and some odd people. And so we have no way of really knowing what the impact could be. I just think with everything else going on, I don't know if the county would really truly want to jump to 50,000. It wouldn't be my recommendation. And don't get me wrong, because I'm all about the seniors that are deserving of this, that, you know, are struggling to get by, but there's also a lot of seniors out there that, you know, have a lot of income coming in.
So what are we at right now?
The county currently is only at the 24,000, which with the sliding scale for the 5%, somebody could get a 5% exemption with an income of $32,399. So if we went to 29,000, which was the one that the state had adjusted to prior, they would get, it would be an income max of 29,000 for 50%, but down to 5%, they could still be making $37,399 and get a 5%.
This says 35.
I just threw a 35 on there,
Okay,
so in
alright.
case somebody was considering something in between. So I did not show you the 29, but we can pass that down and you can look at that. That is where the town of Queensbury is right now, which shows all the dollars in between for the, you know, different incomes. That's how the sliding scale breaks down. Just like it shows here, there's 50%, 45, 40 on down to 5%. So, you know, it's not my call. I just wanted to present it to you all so that you were all aware that New York State did change the limit. And it's something that the county can consider doing if they want to do that. You know, it would have to be a local law, though.
Yeah, we don't have to take any action to leave it in current status.
Correct.
We can
Just leave it alone.
We can leave it alone. We can think about it. We can bring it back. But my only observations are that our policy has been in effect since 2012. The New York State Legislature recently made an adjustment in theirs, increasing the exemption to $50,000. So it just Lexi seems to feel that 29 may be an appropriate number. It's just we can maybe bring it back next month, talk about it some more. Maybe Frank can kind of figure out what the downside will be in terms of you know, what it means in terms of lack of revenue to the county.
Okay.
Oh, please, yeah.
Just remember, when it comes to exemptions work like this. Any of you can apply. There's different exemptions that are out there. You can apply for an exemption, but somebody else has to make up that difference. So we all as a whole end up making up that difference. So if we offer this as a county exemption and you're not a senior, you may see an increase in your tax rate because the money has to be made up somewheres. So, you know, we're still going to set the same levy that we're going to set for the county because that's what we need. It's just if you offer this exemption, I mean, not this year, obviously, because it's too late this year. But if you offer this exemption, it's going to change that. And therefore, it's going to offset in tax rates. And everybody else will just have to pay a little bit more.
Supervisor Bramer.
I agree with you, Chairman, that we should bring it back to look at it. It's been a while. We all know, you know, inflation is high, has been. And we should look at increasing it, maybe not to 50, but
I mean, I think the 29,000 would be a good number. You know, no one else town level wise is at that. Currently, other than the town of Queensberry.
Is there a way of defining, if we went from 24 to 29, of defining kind of precisely what the revenue differential or loss would be?
I think that all of the same people that are right now in this, they would still get the same exemption. It's a matter of how many new people would apply, and I have no way of judging that or being able to tell you, but everyone that already has our exemption at 24,000 in some way, shape, or form would get it, because our 5% goes down to $32,399. So that 29 is still within there. You're just now going to change the sliding scale to go up to 37,399. So that's why I'm saying everybody that already has the exemption would still get this and benefit. It's just probably at a higher percent they would benefit. It's just a matter of how many new people are going to then be able to apply, because it would go up to $37,399. So if somebody falls at that income or less, they can now apply. So there is no way of knowing.
Supervisor Bramer, then Supervisor Dixon.
I just had a quick question, not to be answered today, but is there any way that we can limit the exemption based on their assessed value if they have a $3 million lake house and they have no income because they, like you said, their assets are tied up in a bank account? No, we
I
can't.
just had this discussion with the Queensberry supervisor before I came up here, and that's something that we totally agreed upon, that if there was a way of basing these not just on their income, but also on their assessed values of their homes, because, you know, there is a bunch of people in Queensberry that live on the lake that may have $1 million home or more, and they're getting an exemption.
So we go
So
look into it?
look into, no, it would be, you have to go through New York State and be a whole legislative thing. You
So we
can't,
can't do it.
not us, if you would like to lobby New York State, it could possibly be done, but.
Maybe I'll bring that up to the chair of legislative and rules.
Or
Legislative
possibly
can,
talk with Dan Stack or Matt Simpson
Sure.
and see.
Supervisor Dixon.
I
get right on that.
I think we're falling behind. I think we should at least raise it to the 29.
I'll second that. I'll go with the recommendation, Director.
Motion,
Well, we would have to, what we've done in the past is pass this by resolution, and it should really be passed by a local law. So I don't
Probably
know
have-
the whole process of doing.
Probably go
local
to
law.
rules and legislation.
Put on.
That's what we're on.
Okay,
moving on to Supervisor Stroud.
Yeah.
It's our recommendation that we feel it's appropriate that 29 is maybe the number we ought to.
Yeah, we can get it on it for 12:35. What was I thinking? Sorry.
next meeting too, so if I need to, I can stay if you want to discuss it there.
Any further discussion, any items?
We got a resolution before we do it.
Okay, we have a motion by Supervisor Dixon, seconded by Supervisor McGowan. Any further discussion?
And that was to move it to legislative rules,
At 29.
29.
Any further discussion? All those in favor?
Aye.
Opposed? No opposed, so.
Okay.
Privilege of the floor, Supervisor McGowan.
Yeah, I just wanted to say earlier on the foreclosure things that we were talking about, we can't be the only county that's got this issue. across the United States. So, if our director happens to have a few minutes in her busy schedule to maybe, find out some other common laws that, I mean, is it just a New York State thing? Or can we just get the wording right where the towns and we're all covered and the people can sell their houses? We can't be the only ones having this issue.
Are you talking about for the blighted properties?
Hmm.
So here's the thing with those, I don't know of any other counties that do it as a county thing. I don't, the language that was brought forth, like Supervisor Garrity stated, came from the city of Kingston. Cities handle foreclosures totally different than counties. The cities sell their properties individually. They do not sell their properties at a foreclosure sale like we do. I know down there, the city down there, in Kingston, they basically interview their people before they allow them to buy them. They have to prove that they have the funds. They have to prove ahead of time their plan. So they have to come in with a drafted plan of their steps as to what they're going to do with the property before they're even given the opportunity to buy it. So that is something that I don't know who these people would present a plan to, whether it would have to be to the individual towns, or is it a plan they would have to submit to Charlie Wallace's office? And I don't think that they have any way over there of manning all of these. I mean, again, like I said, you have to prove your financial stability and that you have the money in the bank to be able to, one, buy the home, and two, actually have the money to cover these plans, or provide that you have bank support to be able to do that, to move these forward. So the cities handle things a little differently. I know the city of Glens Falls, they sell all of their properties individually. I know I don't believe anyways, go through that length of a inspection that you have to prove to them what you're gonna do and your financial backing. But when you get down into like the city of Newburgh, the city of Kingston, the cities down towards the city, it's handled differently.
Well, there's got to be some counties that do the same thing that we do. United States is pretty big.
Well, United States, but I don't know what happens throughout United States. Maybe in the state of New York, I could put something on my listserv and see if anybody puts other language in their deeds. To see what I
I mean,
get
it's
back.
just Google it out there and see what comes back. I mean,
Well, we got your phone there. We might be able to Google it right now if you want to.
well, I have economic and growth and development next, so.
It's a very difficult thing to deal with blighted properties.
It
We've
is.
all been through this at the town level. We have all kinds of situations. It's very, very difficult to do. It's very, very difficult to draft a law that allows you to do it. In the scenario that Lexi gave you about Kingston, in order to do that process, you have to start at the town. You go to the town, you explain to them what you want to do, you have to have plans. They have to be stamped by an engineer if they're involved in any kind of structural. You also have, like in town of Lake George, there's no municipal sewer. So you buy a blighted property, you have to assure us that the septic system is in and function, will service the house. So it's a long drawn out process. Then in that process, for your building permit, you end up with the county actually getting a county permit. So, yeah.
I get a motion to adjourn, please. Supervisor Dixon, Supervisor Ross. Those in favor? Most.